This court does not have jurisdiction to determine whether or not a statute is in contravention of the Constitution. That jurisdiction belongs under Article 165 to the High Court of Kenya. This court, therefore, does not have the jurisdiction to assess the constitutionality and or the procedure of ratification of a treaty and or convention. That belongs to the High Court. Therefore, all the arguments, although I didn't get all of them with clarity, all the arguments that relate to the process of ratification of either the Cybercrimes Treaty or other convention and or the United Nations Convention Against Transnational Organized Crime, UNTOC, must fall by the wayside. They have no space before your plate. You can't listen, you can't hear, you can't determine. You know, the question before you is very simple. Is there a legal basis for the extradition of a person from Kenya to the US? That is the question. All these are other arguments about public international law, Vienna Convention on the law of treaties, the difference between a convention and a treaty, whether all treaties are conventions or conventions and treaties, are not helpful to that question. The question is simply, is there a legal basis? To answer that question, the extradition of a person can be based on one, a memorandum of understanding between two countries or more. Number two, an agreement. To illustrate the applicability of an agreement, until 1972, the extradition between Kenya and the United States was guided by the agreement between Kenya and the United States entered into in 1932. 31, that's correct. They're a lot. 1931. It was an agreement which applied the treaty between the US and the United Kingdom. That treaty between the US and the UK was actually the one for 1931, Your Honor, they are confusing me. The treaty between the US and the UK for 1931 was repealed in 1971 without another agreement between Kenya and the US. To that extent, we easily agree with the respondents that there is no agreement and or treaty between the US and Kenya to that extent. Having mentioned the agreement, number three, the extradition between the US and Kenya or any two parties, state parties, can be on the basis of a treaty. That is a little bit obvious. And number four, extradition can be based on a convention. Those are the four possible ways or legal basis for extradition. Parties are bound by their pleadings, correct? We agree. Your Honor, the law students in this class, and there are a number, will tell you that parties cannot plead the law.
Your Honor, law students have no audience before you. They can't
Parties cannot plead the law. Parties plead facts. And therefore, the suggestion by the respondents that the applicant pleaded the Cybercrimes Convention is misleading and incorrect. However, we are bound by the facts in our pleadings. This court has the power, even where the parties don't indicate the law, to apply the appropriate law to the facts that parties are bound to. So that even if we came silent on the law, this court has power and is obligated to apply the correct law. At that point, the applicant withdraws the reliance on the Convention, as was expected by the respondents. And as we earlier did this morning, reliance on the application for extradition is founded on the United Nations Convention Against Transnational Organized Crime, UNTOC. We did not need to make an application to point the court to the law. The next question would be, is the UNTOC relevant to the application? You've been pointed, and I'm surprised I've had a whisper that we have not made an application to introduce you to the law, while we have also been served with the Treaty Making Act and Ratification Act without an application, which is interesting. There need not be an application to point to the law. Thank you, Your Honor.
You don't want to miss your time.
Your Honor, Section 2 of the Treaty Making and Ratification Act, introduced to the court's record by the respondents, defines ratification in the following terms. It means the international act by which the state signifies its consent to be bound by a treaty, and this is very important from this point, and includes, number 1, acceptance, number 2, approval, and number 3, accession. The court will readily agree with us that the use of the word include means, number 1, that list is not exhaustive, and number 2, that each of those listed is an item that amounts to ratification. Then that takes us back to the UNTOC. And we shall provide a list of the state parties to the UNTOC, which I think our colleagues were very busy to have checked.
Your Honor, if I'll object to one issue.
Your Honor, if counsel would allow me to finish.
No.
Okay.
Your Honor, there is foreign materials being relied on.
Yes. Now, what has happened, Mr. Omar, so that we now have received even some from the states. Yeah. Of course, if I find it is correct, I'll make my own decision on that.
You know what I was saying?
Yes.
The state has admitted and they have withdrawn the Convention on Cybercrime. The application then before you.
Just post the time.
Post the time.
Yes.
So that we wanted clarification. If the state concedes that the law cited is not available, then what they can do is to withdraw the application, file a fresh one on the basis of what they are introducing. Because now they are introducing what we are not aware.
I will look at all those issues.
Much okay.
If somebody has withdrawn, I'll probably withdraw the
Much
look at all those issues. Let's remember.
Thank you, Your Honor.
I don't want you to respond to what I already just given just directed at the proceed. I will look at all the issues.
That's okay, Your Honor. Although we can easily point out to you the face of the notice of motion.
I want you to proceed from where you stopped.
Your Honor, where did I stop? These gentlemen, I'm the one who knows how to deal with them. They cannot easily throw me off the rail. Please assist me with the record of the court. Where did I stop, Your Honor?
You are addressing the issue of what amounts to cost.
Ratification. Thank you, Your Honor. Section 2 of the Treaty Making and Ratification Act says that any of those three, which list is not exhaustive, amounts to ratification. And I was therefore pointing the court, this material is actually available online. My colleagues are not very lazy, they will get it.
We have.
That's in jest. That at page 2 of our document, Kenya acceded to the convention on 16th June 2004. That date has an A beside it, which means acceding. Section 2 of the Treaty Making and Ratification Act counts acceding as a part of ratification. Now, what about the United States of America? The last page of the list we have provided The United States signs on 13th December 2000, ratifies on 3rd November 2005. So that the court easily gets the answer to the question, is there a legal basis for extradition without the treaty between the US and the UK of 1931 and 1971? And the answer is yes. There is a convention that both parties have either ratified by way of ratification itself or ratified by way of accession. Now, the next question, which our colleagues have not raised, but which we would like to assist the court with, is that the next question would be, are the offenses extraditable under this convention? And that answer is provided for by looking at Article 2 on the definition of serious crime, Your Honor, Article 2 of UNTOC, the United Nations Treaty we are referring to, defines serious crime. Article 5, 1A and B of the same convention. Article 3 on the scope of the applicability of that treaty. And then, of course, you've been referred to Article 16, Article 4 correctly by my colleague, that it is to the effect that if you do not have a treaty between you as parties and you make it a condition that for you to extradite you need a treaty, then consider this convention itself as a treaty. That probably answers the questions as to whether all treaties are conventions and all conventions are treaties. Article 16.4 says that whenever there is a requirement, precondition for extradition as to the existence of a treaty, then this convention is in itself a treaty. Now, Your Honor, I wanted to mention something on the face of the notice of motion. And this is out of practice, the drafting by parties. Under Article 157.6A of the Constitution, of course, the powers of the DPP to do prosecutions, including extraditions, sections of the Extradition, Contiguous and Foreign Countries Act, the Convention on Cybercrimes Act 2001, which has been withdrawn, and Your Honor, and all other enabling provisions of the law. And all other enabling provisions of the law. This is not strange drafting. All other enabling provisions of the law. Your Honor, Articles 2 and 5 make international law, including treaties and conventions, part of Kenyan law. So, is the UNTOC the law? Yes. Is it a law of Kenya? Yes, by dint of Article 2.6. If it is a law of Kenya, is it an enabling provision of the law? Yes. So, is the argument that they have withdrawn cybercrimes convention so they have nothing to rely on sound in law? No, because all other enabling provisions of the law includes, under Article 2.5 and 2.6, the convention UNTOC. We have essentially proved, Your Honor, at this stage where we are dealing only with the legal basis, we shall address you on the factual basis at the appropriate time, that indeed the return to the question, is there a legal basis for extradition, is a resounding yes, and I thank you.